Pursuant to notice, the Subcommittee on the Constitution meets today to consider H.J.Res.110, the Parental Rights Amendment. The question at the heart of the growing debate over parental rights is the same question that was at the heart of the American Revolution more than 2 centuries ago. What is the source of our rights? The European model held that God gave authority to kings and a government that would hold the rights of men in their hands. The Americans reverse engineered this model and recognized the true foundation of human dignity. We held these truths to be self-evident, that all men are created equal, and that they are all endowed by their Creator with certain unalienable rights, and that government does not create those rights, but merely exists to secure them. The state exists to preserve freedom. Less than 100 years ago, no American would have believed we would ever need to enact laws to protect the rights of parents to direct the care and upbringing of their children, because this right was considered so integral to our way of life and our rule of law. The Supreme Court affirmed this fact in its 1925 decision in Pierce versus Society of Sisters when it stated, quote, "The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations," end quote. Almost 50 years later, in the 1972 case Wisconsin versus Yoder, the court reaffirmed this fundamental principle by stating, quote, "The primary role of the parents in the upbringing of their children is now established beyond debate as an enduring American tradition," end quote. The Supreme Court has thus recognized parental rights as fundamental rights, which cannot be violated unless the state proves it has a, quote, "an interest of the highest order," which cannot be otherwise served. The integrity of parental rights was threatened, however, in 2000 when the U.S. Supreme Court decided Troxell versus Granville. A 4-judge plurality described parental rights as a fundamental, historically, but then declined to use this strict scrutiny test that attaches to this status. In the wake of Troxell, federal and state courts have permitted governmental intrusions onto parental rights ranging from the choice of a school to the most basic aspects of child rearing. State legislatures have restricted parental access to educational information, health records, and even the list of books and media items that their children borrow from the library. Such mandates radically change the long-established authority structure between families and government by forcibly inserting the state between parent and child. Parental rights also face external threats. International law, including widely ratified treaties like the UN Convention on the Rights of the Child, permits the state to override the decisions of fit parents if they believe that a contrary decision will benefit the, quote, "best interests of the child." Even if the United States refuses to ratify a treaty, American courts could attempt to recognize a treaty's principles as a reflection of binding international norms and customs under the doctrine of, quote, "customary international law," and thus override all inconsistent state law. I always wonder if that's the Russians coming, you know? Section 4 of the PRA ensures that treaties of other forms of international law cannot be used to override or modify parental rights. The truths, principles, and knowledge inculcated into the hearts and minds of our children dictate more than any other human factor the paradigm of America's future. One of two people will primarily choose the academic, philosophical, and spiritual substance of what is placed in the hearts of a particular child. It will either be a bureaucrat who doesn't oftentimes even know the child's name, or a parent who would pour his or her last drop of blood out on the floor for that child. Our answer to the question of how we answer who that will be is one of inexpressible gravity. The purpose of the Parental Rights Amendments is to ensure that the American time-honored standard, which recognizes the liberty of parents to direct the education and upbringing of their children, is fundamental. It is placed in the actual text of the Constitution as such. Neither shifting Supreme Court majorities or international law would be able to change the basic idea that parental rights are examined under the high legal standard for the protection of our rights that our Constitution describes as fundamental. And with that, I would yield now to the ranking member of the subcommittee, Mr. Scott, for his opening statement, if he has an opening statement.
Thank you, Mr. Chairman. I'm just sitting in for the ranking member who is not able to be here, but I would like to ask unanimous consent that his statement be entered into the record.
Without objection.
I thank the witnesses, particularly Dr. Ferris, for being with us today.
All right. Well, let me just then thank all of the witnesses for appearing before us today. Our first witness, Dr. Michael Ferris, is founder and chairman of the Homeschool Legal Defense Association and founder and chancellor of Patrick Henry College. Since founding the Homeschool Legal Defense Association in 1983, Dr. Ferris has helped grow the organization to over 80,000 member families. Dr. Ferris has written over a dozen books, a constitutional law textbook, and works on marriage, parenting, homeschooling, political advocacy, and religious liberty. His daily radio program, Homeschool Heartbeat, airs on several hundred stations nationwide. Education Week has named Dr. Ferris one of the top 100 faces in education of the 20th century. Our second witness, Professor Martin Guggenheim, is the Fiorello LaGuardia Professor of Clinical Law at the New York University School of Law, where he has earned his J.D. Professor Guggenheim focuses on child law, child welfare law, and is the author of numerous articles, including Ratify the UN Convention on the Rights of the Child, but Don't Expect Any Miracles. In the Emory International Law Review and Stealth Indoctrination, Forced Speech in the Classroom, in the 2004 University of Chicago Law Forum. Welcome, sir. Our third and final witness, Piero Tosi, serves as senior legal counsel with the Alliance Defending Freedom, or ADF, and that name has changed slightly. Since joining ADF in 2010, Mr. Tosi has focused his litigation efforts on the international human rights law. He earned his J.D. from the Fordham University School of Law in 1996. Prior to joining ADF, Mr. Tosi served as Executive Vice President and General Counsel for the Catholic Family and Human Rights Institute, or CFAM, while running its New York office, where he lobbied the United Nations on social policy issues and established CFAM's public interest law firm, the International Organizations Law Group. And welcome, Mr. Tosi. Each of the witnesses' written statements will be entered into the record in its entirety. And I would ask that each witness summarize his or her testimony or his testimony in 5 minutes or less. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you will have 1 minute to conclude your testimony. When the light turns red, it signals that the witness's 5 minutes have expired. And before I recognize the witnesses, it is the tradition of this subcommittee that they be sworn. So if you'll please stand. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. Now, I will now recognize our first witness for 5 minutes, Dr. Ferris, and if you'll turn that microphone on. Yes, sir.
Chairman Franks, Mr. Scott, members of the committee, thank you so much for holding this hearing and for your leadership on this issue. In 1990, in the case of Employment Division versus Smith, the Supreme Court made a ruling that undercut our long-standing legal standard for the protection of the free exercise of religion. Shortly thereafter, under the leadership of this committee, Congress introduced the Religious Freedom Restoration Act. I had the privilege of serving as the co-chair of the drafting committee for RFRA, and even the greater privilege of working closely with the members and staff of this committee in the passage of RFRA. Mr. Nadler played a key role in the successful passage of RFRA, and I would be remiss if I failed to mention the important role that Staff Counsel David Lockman performed in the effort to preserve religious liberty for all Americans. And RFRA received the ultimate form of bipartisan support since the bill passed unanimously in the House, and I guess it was 97-3 in the Senate. The situation our country faced with regard to RFRA is a perfect parallel to the situation we face today with regard to parental rights. There is overwhelming support in our nation for both the free exercise of religion and the traditional right of parents to direct the upbringing, care, and education of their children. A 2010 Zogby poll found that 93.6% of Americans believe that parents should have the constitutional right to make decisions for their children without governmental interference unless there's proof of abuse or neglect. However, our current law does not match the belief of the American people. Just as was the case regarding religious freedom, The problem with parental rights starts with the Supreme Court decision. In Troxell versus Granville, as the chairman has already indicated, the Supreme Court ruled in favor of the parent, but did so in a way that has led to a serious erosion of the traditional constitutional principle of parental rights. Parents won that battle, but lost the war. In Troxell, the court split 6 ways, and without going through in my summary all six of the opinions, suffice it to say, only Justice Thomas used the traditional test for parental rights, calling it a fundamental right and applying strict judicial scrutiny. But even Justice Thomas said in a properly briefed case, he might consider a different rule. Justice Scalia is noteworthy in the fact that he said that even though that parental rights are an inalienable right under the Declaration of Independence, that they're not constitutionally protected at all because there's no text of the Constitution to support parental rights. Until parental rights are in the text of the Constitution, Justice Scalia says, parents lose every single time. This level of confusion at the Supreme Court has infected the lower courts with a growing level of discord as to the correct constitutional text, although some confusion existed even prior to Troxell. My written testimony includes an appendix with a brief analysis of state and federal parental rights cases since Troxell. I list 24 cases that have expressly rejected the use of the fundamental rights standard in light of the Troxell decision. A pair of cases that I personally litigated explains the situation that parents face when attempting to protect their constitutional rights. Before the Supreme Court of Michigan, I argued 2 homeschooling cases on the same day. The first was for the DeYoung family, who defended their rights using a combination of religious freedom and parental rights. By a 4-3 vote, the Supreme Court of Michigan held that they had a fundamental right to do so. But the Bennett family, who argued simply on the basis of parental rights, had a 4-3 victory snatched from them, rather. They lost 4-3 on the basis that parental rights are not a fundamental right. The net result in Michigan, as according to that Supreme Court, is parents who are religious had the right to homeschool, but secular parents did not have the right to homeschool. One had fundamental freedoms, the other did not. It's my belief that all parents, of whether secular, religious, or whatever religion, should have the fundamental right to make educational decisions for their children. It should not matter, but in fact, it does matter. I've personally litigated dozens, if not hundreds of cases involving invasions of parental rights in medical decisions, educational decisions, religious decisions, and much more. The caseload of one lawyer can only be the tip of the iceberg. Parental rights are under assault, and the correct constitutional standard is not clear as a result of Troxell. Historically, the standard is clear, and the Parental Rights Amendment does one big thing. It places the traditional test for parental rights into the black and white text of the Constitution. It follows the very words and principles of Meyer versus Nebraska, Pierce versus Society of Sister, and Wisconsin versus Yoder. Congress can make history by taking bipartisan action to protect parental rights. Parental rights should not be diminished over time, and parents shouldn't have to guess whether or not their rights are fundamental. It should be in the black and white text of the Constitution. Thank you.
Thank you, Dr. Ferris. And Professor Guggenheim, now you're recognized for 5 minutes, sir. And you might turn that microphone if it's not already on.
I think it's on.
Yes, sir.
Chairman Franks, Mr. Scott, Mr. King, members of the subcommittee, it's a great privilege for me to be here today. I'm here testifying in opposition to a proposed constitutional amendment recognizing the liberty of parents to direct the upbringing, education, and care of their children as a fundamental right, not because I am any less than my distinguished colleagues who are witnesses today, a fervent supporter of parental rights. I would out-elbow to the left and right for that label as someone who proudly regards himself as a fervent and staunch advocate for parental rights. My disagreement is purely over means not ends, but profoundly, I come before you with the straightforward conservative message that we should never tinker with the Constitution lightly, that there is an overwhelming burden placed on anyone who suggests that we need to tinker with the Constitution, and that no careful student of the field could reasonably conclude that that burden is met in this situation. The division of the court in Troxel is, in my opinion, and I am a great admirer of Michael Farris and the work that he does and the principles for which he stands. But I respectfully suggest that the critical disagreement among the justices had less to do with the principle that we're discussing today, that is the importance of parental rights. It had a lot to do with whether a Washington statute that was overbroad in its language should be declared facially unconstitutional or only unconstitutional as applied. It's a very complicated inquiry when a state court chooses to declare a law facially unconstitutional outside of the First Amendment, and that case reaches the Supreme Court. And the scattered opinions spend much more time on that question than on the merits of what parental rights are. Suffice it to say that the Supreme Court of the United States has held fast to the principles supporting this amendment, the merits of them, through every court from the Lochner era through the Roberts Court. And it's useful to read the plurality's reaffirmation in 2000 of these principles. The court said that we have always confirmed that there is a constitutional dimension to the rights of parents to direct the upbringing of their children. We've recognized the fundamental right of parents to make decisions concerning the care, custody, and control of their children. The history and culture of Western civilization reflect a strong tradition of parental concern for the nurture and upbringing of their children. This primary role is now established beyond debate as an enduring American tradition. And indeed, it is. To suggest that we need Congress to come to the rescue because the court has lost sight of this fundamental notion, I submit, is wrong-headed and incorrect. It is a very odd idea to propose a constitutional amendment to place into the Constitution the exact language that the Supreme Court has upheld through 5 different courts from 1920 to 2000. But there is more. We live in a country with overwhelming support for parental rights, as Chancellor Farris has just reminded us. Not only would it be unprecedented to amend the Constitution at a time when the protected liberty involved is not threatened by the courts, but in our constitutional democracy, it also matters whether the allegedly endangered group needs constitutional protection from the tyranny of the majority. Parents constitute the overwhelming majority of Americans. In 2000, a national survey revealed that 86% of women and 84% of American men of voting age are or were parents. There simply is no reason to believe that the values celebrated in this proposed amendment are not widely shared by Americans generally and by voters in particular. Thus, there is neither a reason to worry that the courts or the legislatures are insufficiently sensitive to parental rights, Would there ever reach the point that my distinguished colleagues here today suggest we have already, that there is really a threat to parental rights? We surely would have the means to address it at that time, but we aren't close to that at this point.
Thank you, Professor Guggenheim. Mr. Tozzi, you're recognized now for 5 minutes, sir.
Thank you, and I'd like to thank you, Chairman Franks, and the subcommittee for inviting me to testify in favor of parental rights amendment. Specifically, I've been asked to address the United Nations Convention on the Rights of the Child and how it would affect the rights of parents and impact the welfare of children. Begin by saying that the convention is the most widely ratified treaty, bar none, and it is only the United States and Somalia that have not ratified it, but it is my position, nevertheless, that the convention is fundamentally flawed, and despite the good intentions of many, it ultimately fails children. The fundamental problem, as I see it with the convention, is that in pertinent part, it envisions the child as an autonomous bearer of rights, divorced from his or her family, with the interventionist state seen as the ultimate guarantor of such rights. And such a perspective implicitly pits children against their parents. Indeed, the Committee on the Rights of the Child, which is empowered under the Convention to receive reports of states' parties, has interpreted these rights as rights to be secured against parents, as opposed to civil and political rights to be secured against the state, and in fact do invoke the state as against the parents. Now, while there are good provisions in the convention, and it does mention the need to respect the responsibilities, rights, and duties of the parents, and does reference the importance of the family, there nevertheless is this internal tension with that of the child as the autonomous rights bearer. And I think this rights-based approach lends itself to thinking in dialectical terms, with parents seen as oppressive and exploitative. And much of the reason for this, I think, is because of the Convention of the Rights of the Child grew out of thinking in the 1960s and the 1970s, which saw the child rights movement as part of a general liberationist movement. Writing of scholars such as Samantha Godwin, for example, in a recent article of hers titled Children's Oppression, Rights, and Liberation, where she links the child rights movement with prior liberation movements, I think is indicative of this approach. And I think this problem is exacerbated by the role that the Committee on the Rights of the Child has taken under the Convention. The Convention says that members of the Committee shall be experts of high moral standing and recognize competence in the field covered by this Convention, which essentially means child rights experts. It's a self-selecting group. And it tends to be those people that would interpret the rights of the child as against parents. Now, this committee frequently issues directives that extend beyond its power and opines as to matters that are not covered by the text of the convention. For example, the committee has criticized the United Kingdom for laws that allowed parents to opt out their children out of sex education courses. They did this on the grounds that the excluding children, by parents excluding children, this amounts to a denial of the child's right to express his or her views freely. Likewise, the committee has instructed the government of Japan that they must guarantee the child's rights to privacy, especially in the family. Also, the committee has called for access to counseling and reproductive health services by children without the need to parental consent. They did this as recently as 2008 when Bulgaria and Georgia appeared before the committee. These views undermine the parent-child and the family bond, and ultimately they harm children, is because they drive a wedge between parents as the children's natural protectors and the children themselves. And in the worst case, it leads to calls for intervention by the state to enforce the rights of the child. We have seen state actions, and I refer in my written remarks to cases from Sweden and Spain, where opposition to parents and taking parents from their children from their parents, homeschool parents, has been justified by reference to the Convention on the Rights of the Child. Here in the United States, of course, we do have, as my colleagues have referenced, venerable Supreme Court precedents such as Meyer v. Nebraska, Pierce v. Society of Sisters, Wisconsin v. Yoder. However, and I do disagree with my esteemed colleague here, we do see an erosion of parental rights. The case, for example, of Parker v. Hurley, which involved the parents' right to opt out of public school courses where materials that they deemed inappropriate and contrary to the moral values they were teaching their children was denied. Now, the court there did not cite the reasoning of the Committee on the Rights of the Child, but such reasoning does strengthen the arguments that advocates make. We've also seen elsewhere courts that have referenced the Convention on the Rights of the Child as being incorporated in customary international law. I think I'll conclude my remarks here, but I'm certainly willing to address that further should you like. Thank you.
Well, thank you, Mr. Tozzi, and I'll recognize myself now for 5 minutes to begin questioning, and if it's all right, I'll start with you. I'm going to go ahead, if you'll grant me diplomatic immunity, and in the interest of full disclosure, suggest that I believe a parental rights amendment of this sort is a vital addition to the Constitution. I think that the Constitution was always meant to recognize these things, but it was never really memorialized in the text. And one of the things as the chairman of the Constitution Committee here that's probably one of the greatest disappointments to me is the willingness of some courts to fundamentally ignore the clear written text and intent of the Constitution to come up with a wholly different conclusion or ruling. And if they will do that with obvious language, my fear of what they might do at some point with no language whatsoever is one that it nags at me. Given the magnitude and the importance in my opening statement, I suggested that, you know, if we look to the future, any country that looks to any future must realize that the things they teach their children will have as profound an impact as anything that you can possibly imagine. So we will leave that decision in the hands of one of two people. It will be the state or the parents in essential terms. So I think the conclusion here is very significant, and in all deference to Professor Guggenheim, I think there's a moment in the life of every problem when it's big enough to be seen coming and still small enough to be addressed. And the court's history here gives me a sense that clear language would be of some help in making sure that we don't step away from what is the professor's absolutely right on, that this is something that I think all of us essentially agree on, that parents are the first decision makers. With that, Professor Tozzi, sorry, Mr. Tozzi, you talk like a professor, so. You made a strong argument against the UNCRC, but if if we've not ratified that treaty, and again, this is a rhetorical question to give you an opportunity to what is the big deal about it? What threat does it pose in terms of the courts looking to, quote, customary international law? We've seen the Supreme Court begin to recognize customary international law as influential on domestic issues. Roper versus Simmons and Graham versus Florida probably be good examples. But do you have any concerns that a parental rights case before the Supreme Court could be influenced by international law or treaties? And if so, what are your concerns? And kind of give us a perspective.
Yeah, well, probably the most significant case that did reference the Convention on the Rights of the Child, you mentioned Roper v. Simons and the Florida v. Graham v. Florida. In both those cases, the Convention on the Rights of the Child was cited as influence, or as an example of world opinion. That norms had shifted, and the United States was laggard. I believe the dissent of Justice Scalia in Roper v. Simons addresses this and some of the constitutional problems. He sees it really as a backdoor way for the courts to take a power that does not belong to them. The power to ratify a treaty does reside with the executive branch, with the advice and consent of the Senate, not the judiciary. So there is that constitutional issue as well. just want to also state that I'm not here, the substance of the issue in Roper, for example, the juvenile death penalty, I'm not opining as to that or speaking out in favor of the juvenile death penalty, but rather the constitutional issues. The customary international law is usually referenced in cases involving the Alien Tort Claims Act. There is an expected decision by the Supreme Court in the next term, the Kiobel versus Shell oil case, which will discuss, I think, the limits of customary international law. Customary international law it does have its place in our jurisprudence, but not an expansive notion that would incorporate everything. And there have been courts, Ninth Circuit decision, which on the Alien Tort Claims Act, which has referenced the Universal Declaration and other treaties as being part of customary international law. Various courts have also referenced the Convention of the Rights of the Child as being incorporated in customary international law, including several opinions in the Eastern and Southern District of New York. So.
Well, thank you, Mr. Tozzi, and I now recognize Mr. Scott for 5 minutes.
Thank you, Mr. Chairman. Professor Guggenheim, does a treaty become binding law in the United States without implementing legislation?
I'm not an expert. I don't want to give a definitive answer. Were we to formally ratify the convention, it would be citable. It's not self-executing, but it would become material to use in courts. But there is a country-mile distinction between what happened in Roper and Graham, both Eighth Amendment cases where a critical inquiry is evolving standards. And the world standards absolutely forbid, in plain language, the sentences that the states had imposed on those juveniles. So the court naturally, but there is nothing like that.
But that's not binding on the United States. Without
now it's not in any sense.
Well, no treaty is binding in the United States without implementing legislation. I mean, you can't. The treaty itself does not self-execute, as you've said. You need subsequent legislation to make it the law of the land. One of the things that we are working on and would need to inquire is how the present law would change if we had the constitutional amendment. And under present law, is there any challenge to parental rights under current law when the parents are operating in the best interest of the child?
Under current law, there really are two different critical categories of parental rights. Education, deciding the details of your family's upbringing are, of course, the major work of Chancellor Farris and a very important example. But in addition to that, the two areas are intra-family arguments over access to children. That's what Troxel included.
But if the parents are operating in the best interest of the child, is there any question that would be, you don't need a constitutional amendment for that?
Of course not. Anytime parents are acting in their children's best interests, the inquiry ends.
So if you have situations that are not in the best interest of the child, those are the kinds of situations that would be protected under a constitutional amendment. Is that right?
It is. The question would be: is there an interest of the highest order to trump the parent's choice? The answer is yes. It could mean that children's best interests would be not invoked because of a trumping principle.
And Dr. Farris, how would this operate if you're not operating in the best interest of the child? How would that affect medical decisions in terms of denying children access to reasonable medical treatment because the parents do not want to have the child's best interest at heart?
Mr. Scott, the best interest standard is a dispositional standard in our law. It's not a jurisdictional standard. You have to first determine that the family has harmed the child, either abuse or neglect, and then you go to the best interest standard. When we automatically start invoking the best interest standard, it's a subjective standard that means the government gets to decide what it thinks is best for the child. And I believe that the government should not be able to invoke that dispositional standard until it's first proven the jurisdictional elements of abuse or neglect. So you don't start with the sentencing standard or dispositional standard. You start with the jurisdictional standards. And what the government's doing in far too many cases, and mostly with people who don't have the ability to afford counsel, and they're not lucky enough to get somebody like Professor Guggenheim or me, who basically does pro bono parents' rights work. You can't get a dime between us in terms of what we think the law should be. But the reality is the lower courts and the agencies are running over parents on a daily basis.
Well, at some point, some parents just are incapable of operating in the best interest of the child, and if you give them total control, notwithstanding the unreasonableness of their action.
There's no doubt that at some point in time, parents abuse or neglect their children. And when that happens, then the government gets to determine what it thinks is best for the children. But to use the best interest standard, the Washington State Legislature put the best interest standard as the jurisdictional standard in the early 1980s. And under that, they had two cases. One went to the Supreme Court of Washington called In re Sheila Marie. And in that case, Sheila Marie was a 13-year-old girl, was smoking marijuana, sleeping with her boyfriend. The parents grounded her. And the state took the girl away from her parents, even though the court held the rules were reasonable and the method of enforcing the rules were reasonable. But nonetheless, because there was conflict between parents and child over these standards, the state had jurisdiction and removed the girl. That's what happens when you start with best interest. You don't start with best interest, you start with harm. And when you go to after proof of harm, abuse or neglect, or a divorce or something like that, after proof of brokenness, then you go to the best interest. If you start with best interest, that's the very problem. Because best interest necessarily means that the government gets to substitute its subjective judgment about what's right for the child over that of the parent.
Thank you, Mr. Scott. I now recognize the distinguished gentleman from Iowa, Mr. King.
Thank you, Mr. Chairman. I thank the witnesses, and I turn first to Dr. Ferris and ask, what's the legal definition of a parent within the context of our discussion here?
Under the amendment, under the PRA, I think it would turn to state law to determine who's a parent under state law. So it'd normally be biological or adoptive parent, but it would be that would be a state law question: is who's a parent of this child under state law?
You would all concur the other witnesses, Professor Guggenheim and
Yes.
Mr. Tazi?
Yes.
Thank you. And so this complicates this understanding for me. If we have states that define parents as parents, legal guardians, that's what I would view as a definition of a parent under the law that I'd like to see. If it gets expanded into grandparents, aunts, uncles, brothers, sisters in the whole or half-blood, how does that affect this potential amendment to the Constitution, Dr. Ferris?
It would, first of all, constitutional amendments only affect disputes between the government and the parent. It won't affect any kind of intra-family litigation directly. Now, except if there's a state law like the Washington state law that wasn't just grandparent visitation, it was random third-party visitation in that state statute. But it's a dispute between the government and a person exercising parental authority under state law. So if the child was living with the grandparent under state law, that grandparent had parental authority, then the amendment would protect them.
Okay, well, I'm thinking of this. I'm thinking of parental notification laws in the event that a minor child would be seeking an abortion, and parental notification or parental consent laws and the definition of a parent within that context. And as I read this amendment that's the subject of this hearing today, and I would think that if the state grants an authority of consent to an aunt or an uncle in the whole or half blood, that would intervene between this parental rights. So I don't know what effect this amendment would have if this amendment doesn't trump that kind of a state legislative decision to intervene.
In my opinion, Mr. King, if a state legislature gave the right or the power to perform parental notification in an abortion context, or really any context, to a non-parent, that statute would be subject to constitutional challenge. And if I was on the court, I guarantee you the parent's going to win that case. But we would have to go through the test of, is there a compelling governmental interest in doing so? Now that doesn't, in the abortion context, there's the countervailing fundamental right of the pregnant woman that's involved, and it gets messy. And this amendment would not settle any of those questions. But a dispute between a randomly named aunt and a parent, this amendment would speak to that and would uphold the superior right of parent to be the one notifying in any medical situation, absent proof of a governmental reason for intervention and taking that right away from the parent.
I won't examine that question any further because I think you've posed the viewpoint of the breadth of the question that I raised. But there's another question that occurs to me as I read the amendment. In a way, I'm going to pose this to our chairman as I prepare to yield to him, and that is, it says that this article shall not be construed to apply to a parental action or decision that would end life. And I'd like to yield the balance of my time to Chairman Franks and ask if he could help me answer that, and then do whatever you'd like with the balance of that time, Mr. Chairman.
Well, thank you, Mr. King. I think we're going to go ahead and have a second round of questions here just for clarity. So I'm going to go ahead and do that. So you're welcome to finish your time out if you like.
Would the gentleman yield to me?
Absolutely.
Do you have a short answer to that particular question that I posed? The article shall not be construed to apply to a parental action or decision that would end life. And I'm happy to wait until the next round if you'd prefer.
Oh, go ahead.
Would you like me to answer?
Yes.
That language means that if the parents want to terminate the life of their child, some other source of law is going to have to answer the parental rights issues in it, not this amendment. And that was done as a result of concerns raised by National Right to Life. And so to satisfy those concerns, that language was drafted, although it states a broader principle that if you want to kill your child, you're not going to be able to claim a parental right under this amendment. And it restates in another way, I believe, the compelling interest test, that you don't have a right to terminate the life of your child, whether you're going to starve them to death, lock them in a box, or whatever. That's the broader principle stated by that subsection.
Thank you, Dr. Ferris. My time has expired, and I yield it back. Thank you, Mr. Chairman.
Thank you, Mr. King. We'll begin a second round of questions here. Oh, Mr. Conyers, I'm so sorry, sir. Please forgive me. He just came in surreptitiously. And I would now recognize the distinguished ranking member of the full committee, Mr. Conyers.
Chairman Franks, I apologize for coming in late, and I appreciate being able to just ask a basic question of Attorney Piero Tausi. What, sir, do you happen to think may be the weakest part of Professor Guggenheim's presentation about this subject of constitutionality, in which he has posited that that there's no need to tinker with the Constitution, and that there's no genuine crisis. How would you respond to that?
Well, thank you. I'd like to say, first of all, that much of Professor Guggenheim's work I do admire, and there's a lot that we do agree with each other on. I think, however, that he has focused on certain cases, and certain constellations in our constitutional system, but ignored certain trends. And I did reference the Parker v. Hurley case, which involved the right of parents to opt their children out of public school curriculum where they disagreed as a matter of moral principle with the content. And I fear decisions in this vein in particular, and I don't think that Professor Guggenheim adequately addressed that. But I do want to say that in many measures, we certainly do agree, and I'm an admirer of much of his work, though not all of it.
Thank you. Dr. Michael Ferris, what is your analysis in terms of the Guggenheim postulate that there really isn't much problem here that would warrant a constitutional amendment?
Professor Guggenheim and I are very much alike in a lot of ways. He teaches constitutional law at New York University Law School. I teach constitutional law at Patrick Henry College. He litigates for parents. I litigate for parents. Wearing our constitutional professors' hats, we get into the discussions of what's the Supreme Court really doing? What's that court really thinking? Well, that's not the whole story. The litigator of me says, I've got to face lower courts every day. And I've supplied to the committee 24 reported appellate decisions from state and federal courts where they have interpreted Troxel the way I interpret it. And so it's not a dispute between constitutional professors that matters. It's how is it really working in real life? And how it's working in real life, unfortunately, is the way that I say Troxel is. Both of us would like the same result. Both of us would like parents' rights to still be fundamental. Yeah. Both of us would like there still to be a compelling interest test being used. But that's not what's happening in real life.
Right.
And so, for example, in the Court of Appeals...
Well, let me thank you for that, pointing that out. And I want to just turn to Professor Guggenheim for my remaining time to help us see what threads of similarity and unresolvable differences exist in this discussion. And I thank you very much, Dr. Ferris.
Some of what I'm hearing creates a dilemma for me personally. If this were a hearing into the question, have we set something into motion that disserves families and children by permitting states to intervene too easily to remove children from their parents and families of origin, put me on the first list of witnesses to complain about what we're doing. But if I may say respectfully, this Congress is a major agent in that act. And if we were here to complain about the fact that the United States has the highest number of children in state-ordered foster care of any nation on earth, mostly from poor families, overwhelmingly poor, impoverished families, and we asked, should we do something about it? I would commend Congress to amend the child protection laws and explicitly say no child should ever be removed from a parent's home except for reasons of the highest order. We don't need a constitutional amendment. We need legislative change. We don't go first to amend. If this distinguished body thinks there's a problem, we can fix it tomorrow by changing the legislation. We have that power. We don't need to pretend we need a special law to trump what we're doing. We can control our own actions. And I could stand before you if we want to turn this hearing into the question, are we doing enough to ensure that children are raised by their families in the United States? I do not think we are. But I didn't understand that to be the question before us. The question before us is, do we need a constitutional amendment to fix that problem? The answer, in my opinion, is no.
Thank you, and I'd like to thank Chairman Franks and hope that this can be the subject in the future of a further consideration of this distinguished committee.
Thank you, Mr. Conyers. Dr. Ferris, votes have been called, and I'm going to go ahead and start the second round here, and we'll just see how far we get, but I'm going to try to be as brief as possible. You know, I've already suggested to you that I think the absence of constitutional language to clarify this is at some point going to be an issue, and I remain convinced of that, not because I disagree with much of the very passionate and very well-stated testimony of Professor Guggenheim, but simply because I believe that there has been this trend of courts to begin to play the role of legislator, and at least this is a firewall in that regard. And in my mind, you have really identified the foundational issue here, and that is the best interest of the child. In my testimony, once again, I said one of two people will answer that question, and it will be the state or the parents. And in my judgment, the parents are of such import in this case that this is one of the reasons that I think this amendment is, or some type of amendment like this is important, because it says that in who decides the best interest of the child, that we're going to give the clear advantage to the parents unless there is previously a proof of or an indication of harm. So with that, if I could ask you once again to sort of elaborate on this best interest of the child argument, and also you said in your testimony that that this thing should be a fundamental right. Can you give us some more examples from across the country of what happens to parents when their rights are not considered fundamental?
Mr. Franks, I can take a few cases out of my own practice to explain. One is another Washington State case that focused exactly on the best interest standard. In that case, in Island County, Washington, a 13-year-old boy complained to his school guidance counselor, who brought in a social worker, that his family took him to church too much. They went to church Sunday morning, Sunday night, Wednesday night prayer meeting. And the social worker was outraged at that level of church, and under Washington State statute that's since been repealed, the government could intervene for the best interest of the child without proof of harm. They removed that boy on an emergency basis, and I was at the hearing the following week to review that, and the judge said, I think this boy should go to church just once a week. That's what happens when the best interest standard becomes the sole issue. If you don't have the ability to say, first you must prove harm, an interest of the highest order not otherwise served. If the government gets to make subjective judgment calls, you get judges deciding how often a kid goes to church. That's a parent's call, not a judge's call, not a social worker's call. There's a case I was before the Supreme Court, or excuse me, the Court of Appeals of Michigan just last week. In that case, a family decided that after having surgery for their son, remove a tumor, and a round of chemotherapy, that was enough because the boy was testing clean of cancer. And their family doctor was giving continuing PET scans. And the social services agencies hired a private lawyer because the prosecutor refused to prosecute the family, and prosecuted the family for medical neglect because the family did something different than what the doctors wanted. And in that case, the sole issue is, do parents get to decide, or do the doctors and the social workers get to decide what's appropriate medical care? It's not a case where there's clear harm. It is a gray zone case. And we're seeing more and more of these cases where parents are losing their ability to make good parenting decisions. And it's because the government thinks it gets to decide what's best for families, and they do so most often for poor families, for middle-class families, for people who can't stand up for themselves. And the reason we need a constitutional amendment is not because every case gets before the Supreme Court. I want social workers who are dealing with a family to know there's a constitutional amendment here. When I'm attacking this poor family, these people have real rights in black and white that I can't ignore. If we're just based on inferences and the debates that the professors have, social workers don't pay attention to that. social workers will pay attention to black and white constitutional rights. We need to do something for families if we're going to stop this erosion of parental rights.
Well, thank you, Dr. Ferris, and I'm going to end my questioning here by simply stating that, once again, I think you've articulated it well, that who decides what is in the best interest of the child. Unless there is clear, convincing evidence that the child is somehow being harmed, I think unless we are willing to just leave that to chance, that it is very important for us to pass an amendment like this, making it clear that parents have the first and most fundamental right to decide the upbringing and education of their children. Now, we might also look into something regarding one of your cases to maybe get a judge to say that members of Congress might attend church at least once a week or something like that. It might be good for the country. I don't know. That's just something that we can throw out there for consideration. With that, I would yield to Mr. Scott.
Thank you, Mr. Chairman. Dr. Ferris, was the case involving church attendance appealed?
No, it was not. The judge told the parents, if you don't give your son or don't agree with my ruling today, I'm going to remove your child. And I could not assure the family that they would keep custody while we appealed, and they just simply caved in.
The problem with that, obviously, is if you have a bad decision, you don't go to constitutional amendments if it was a bad decision.
No, Mr. Scott, that's true. But within a week or a month, it was a very short period of time. It's been a while ago, and I can't remember the exact sequence. The Supreme Court of Washington did issue the decision I referenced earlier in the same exact law, in re Sheila Marie, and they held that the statute's ability to overturn parental decisions was constitutional. And so even though that particular fact pattern wasn't appealed, a very parallel fact pattern involving parents grounding a girl for smoking marijuana and sleeping with her boyfriend at age 13 was appealed, and that one was lost at the Supreme Court of Washington level.
Well, our time is very limited. If you could just give us examples of cases that where the best interest of the child is where the decision is in the best interest of the child, and the courts have gone other than with the parents acting in the best interest of the child, and cases where the court has decided that they're not acting in the best interest of the child, exactly how this constitutional amendment would change things. There's some limit to acting not in the best interest of the child that I think you would want to protect the child from. And I think you're in the gray area, and if you could help us out, I'm not sure we can do that in the time we have left, but if you could help us on that, it would be helpful.
Mr. Scott, I think Professor Guggenheim and I would agree on this exactly, is that the government's authority to intervene should require a prior showing of harm to the child, abuse or neglect, or something of that nature.
Have cases been shown where the family is acting not in the best interest of the child, but the child was not harmed, a harmless error?
Well, let's take the case, the Nebraska case, that would be illustrative of this. The Douglas case? Yeah, where this lady turned her child over to social workers for a voluntary period because she was having problems with lactose intolerance and some of her own problems in her life. And the government took the child because they thought it was in the best interest of the child to take it, and they terminated her parental rights. And the Court of Appeals in Nebraska said that you can terminate parental rights when the parent is not capable of doing what's best for the child. But the Supreme Court of Nebraska overturned that, saying that's too flimsy a ground to terminate parental rights. But that's what happened. Best interest is too flimsy a ground. We should not be able to take...
So the law in the land in that area is okay under present constitutional standards?
The Nebraska Supreme Court got it right.
I mean, the fact that you got a trial-level court decision that isn't right, I mean, we got to go through general standards, and the idea that you can find a case where a trial court didn't get it right is not the grounds for a constitutional amendment.
I have 24 appellate decisions reported attached to my testimony where the courts didn't get it right. 24. It's not one,
Well,
it's not two.
Well, yeah, but the appellate court got it right.
No, well, in that particular, the Nebraska case, yes, that one was resolved correctly, but I've listed for you 24 cases in my written testimony, where the courts didn't get it right. And the question is...
Where the appellate court did get it right?
No, did not get it
Okay,
right.
okay.
They have said, the correct legal standard is this. Are parental rights fundamental? That's the right standard. That's the right question.
Yeah, and that's kind of where we're going to try to, that's going to be the gray area, because if parents are operating not in the best interest of the child, at some point, the government ought to step in and protect the child.
No
I mean,
parent has the
say-
right to harm their child.
Well, what would this amendment do on corporal punishment?
This amendment would continue the traditional law that moderate corporal punishment would be within a parent's authority.
It would not
if they
change-
abuse
it
the
would-
child, it would not protect them at all.
It would not change present law?
It would not change traditional law.
Well, thank you. Once again, you've emphasized when we talk about best interests, is who decides what's the best interest of the child, and what does that encompass. And it is a question of inexpressible gravity, and I want you to know I appreciate all of you for being here today. Without objection, all members will have 5 legislative days to submit to the chair. Oh, I'm sorry, surreptitiously again. Okay. Submit to the chair additional written questions for the witnesses, which will be forwarded to them, and they will be asked to respond as promptly as they can, so their answers may be made part of the record. And without objection, all members will have 5 legislative days within which to submit any additional materials for inclusion in the record. With that, again, I sincerely thank the witnesses for joining us today, and the members and observers, and this hearing is now adjourned.